Soldiers of a broken world, with tattered banners let your rage unfurl. Stand against tyranny that's deep and old. Power to the people, hearts burning bold.
Good morning, ladies and gentlemen, or whatever time it is, wherever you happen to be tuning in from on this corporate tax plantation. You'll have to forgive me this morning. I am extremely exhausted, so if I don't fluently convey what I'm attempting to teach this morning, you'll have to cut me a break. The wife and I were out of town this weekend. I work third shifts, but I switched my schedule around, had to get up for checkout at the hotel, and you guys know how that is. So been up for about 20 hours, but we should still have a good show this morning. I plan on going through this morning. We're going to talk about the illegitimate. Well, first we're going to talk about jurisdictions, the main two, right? Because I've told you there's 5, but we need to break it down more simply. It'll help the Jurist Society, the law class that I have on the weekend, and the Jurist Society members. It'll kind of save some time explaining jurisdictions. And plus, I want to teach law to everybody, not just the Jurist Society members get the exclusive stuff. Obviously, they're serious. That's what we're doing there. But I want to give good quality content to everybody, and everybody really needs to learn the 2 main jurisdictions, which are civil law and common law. Common law being largely unwritten for many centuries, and then of course infected with trust law through the Magna Carta, versus civil law, which is essentially statutory law. It's law written by men to govern civil society. It's also known as Roman law. And we're going to go through all that. Then we're going to talk about the Bar Association, how they are your enemy. They're the great enemies of all mankind. They're merchant attorneys. They're pirates. They're Neptunes. They are Grim Reapers. That's essentially what they are. They are the Grim Reapers. They're the undertakers of the soul. So, and then the judge, of course, is the devil or Osiris, or however you want to look at him in his black robe with his phallic symbol in his hand that he bangs on whatever's bench there, right, which is a bank, by the way, but I digress. And then after that, if we have time this morning, because I don't know how long I'm going to even be able to make it if I don't fall asleep sitting here talking to you, we are going to discuss how there is no money. There is no money in this country, and there is no money in any country that you may be tuning in from, unless you guys are using gold and silver or something that's actually tangibly valuable. And I'm going to show you Supreme Court cases that back that up. In one, and I hope we get to it, one extremely important case called the Credit River decision, Jerome Daly case, where the judge actually was unalived after the case, and so were some of the juries. I'm not laughing about that. I'm just, it's like that's how serious that was, a serious kick in the nuts to the banking system, and it was right when Nixon took us off the gold standard. But let me say hi to everybody in the chat this morning. We've got, let me go up to the top here. We got Dylan, good to see you, one of our Jurist Society members. We got Beyond Elemental, good to see you, of course. And we have One More Quarter, good to see you. We have Dylan's been chatting it up in there. So Dead and Drummond, good to see you, another one of our Jurist Society members. Peg's Place, always good to see you. Walk and Axel, good to see you. And yeah, she says you plan on saying, listen, no big deal, because whether it's whatever people are interested in or whatever they are capable of doing. Like I said, I'm going to provide quality content for everybody either way. That's just how I am. So Jerry, son of Mick, good to see you, brother, all the way from across the pond. Osram, good to see you. And I think we got Mike, another Jurist Society member, Shawnee B. And I hope I don't think I missed anybody. Like I said, I've been incredibly sleep deprived right now, but we're gonna bang this show out. So what I want to start with discussing is jurisdiction, right? And so generally when you hear the word jurisdiction, people think, oh, like your county jurisdiction or specific state jurisdiction, but those are not jurisdictions. Those are venues within a jurisdiction. When you're talking about jurisdiction, the word jurisdiction literally means law words, juris, law, diction words. I tell you this, you guys this all the time until you're sick of hearing it, but the more you hear it, the better you'll remember it. So when you ask the judge what jurisdiction is this, and he or she tries to pull some bullshit on you and says, oh, well, this is such and such county. And no, that's not what I asked you. I need to know what's the nature and cause of this instant offense or case, right? I need to know what the nature and cause of this proceeding. That's the word I was looking for. See, there's one of my being tired. I need to know what the nature and the cause of this proceeding is exactly. And it's your constitutional duty, to tell me. I have the right to face my accuser, and I have the right to know the nature and cause of the charges against me. And so, then you give them some examples. Is this equity? Is this common law? Is this equity? Where are we at here? And so essentially equity, when this nation was formed in the United States, we borrowed equity and just kind of blended it in at law. But as I'm going to show you in just a second, or just a few moments, the judges or the courts always made a distinction, because common law is run by us. And then, of course, equity and admiralty and all that actually has a judge. That's one of the big differences. The common law courts do not have a judge. They have a justice of the peace that acts as a magistrate, or some other magistrate who's basically just a paper pusher, has no tribunal authority. Sound is lagging? Well, that's no good. Can you guys hear me okay? Let's see here. Where is my Wi-Fi connection? Yeah, everything's good. Well, that sucks. Okay, so Dylan says it sounds matched up on his end. So it may be you, Osram. I don't know. LJ says it sounds fine. Good to see you, LJ, by the way. All right, everybody's saying 5x5, Osram. So, yeah, I'm thinking it's probably going to be on your end. But anyways, so where was I? Civil jurisdiction versus common law jurisdiction. Yeah, so common law jurisdiction, the magistrate has no tribunal authority. So it's the magistrate is independent of the tribunal. And what that means is that the magistrate decides neither the facts or the law of the case, is merely there as a paper pusher and just to do what they're told. That's what happens in a common law proceeding, at law, right? So the courts always make a distinction between suits at law or in equity. But then once they got everybody under the trust indenture and 14th Amendment citizenship, they abolished the distinction because they slowly but surely moved everything from common law into purely equity and the enforcement of trust law, which takes place in equity. So we're going to go through and look at exactly how these are different, because a lot of attorneys do not even know any better. They're not even taught this stuff in school. They're not taught law. They're just taught procedure. They're taught, obey the judge. He's God. And this is how you file these motions. You got to leave this spacing on the edges of the page with these paragraph spacings, all that. That's what they learn. They don't actually learn law. So they wouldn't even be able to tell you this, but civil law is entirely opposite and contradictory to common law. So we're going to take a look at that. And of course, and it's not supposed to be part of you have equity, but it's still a suit in equity. And it's not supposed to be like a general civil law, right? Well, there is one state in the Union, which we'll look at, that was always civil law. And that's because when Thomas Jefferson bought it from Napoleon, it was already under civil code. From being it's Louisiana, from being under France, they had a civil code as opposed to statutory law that reflected common law. So that's how it started to get infected into common law lexicon. But all right, let's take a look at this real quick. So we're going to go to Black's Law first, and I'm just going to share the window because we're not doing videos this morning. So all right, we're going to have to zoom in significantly. So civil law, this is Black's Law, 2nd edition. Okay, so the word civil law, it says the Roman law and civil law are convertible phrases. Okay, this is not Rome. We're not supposed to be under civil law, but we are now for all the reasons I usually explain to you. It says Roman law and civil law are convertible phrases. So when they try to tell you that, and it's really not law, that's a misnomer. It's commonly referred to as law, but it's statute or code. That's it, which is man-made law. And we're going to look at some Blackstone this morning too, that really defines the difference. But it says they're convertible phrases, meaning the same system of jurisprudence. It is now frequently denominated the Roman civil law. The word civil, as applied to the laws enforced in Louisiana, see, that's what I was talking about, before the adoption of the Civil Code, is not used in contradistinction to the word criminal, but must be restricted to the Roman law. See, because criminal law would be under common law, right? That's, you have to actually have a victim to have committed a crime. Now everything's civil law, and they have not restricted they have not restricted the word criminal. What am I trying to say? See, this is me being tired. Basically, they've put you under statutory law, and you don't have to have a victim to be a criminal. That's what I'm trying to say. So told you that good old 20 hours without sleep. But anyways, it must be restricted to Roman law. It is used in contradistinction to the laws of England and those of respective states. So it is the opposite of common law, right? So it says right here, the system of jurisprudence held and administered in the Roman Empire, particularly as set forth in the compilation of Justinian and his successors, comprising the Institute's Code, Digest, and novels, and collectively denominated the Corpus Juris Civilis, as distinguished from the common law of England and the canon law. So it's an entirely separate jurisdiction. Now watch what these scumbags did between 4th and 6th editions of Black's Law. So we pop over here. Now we're going to look at the definition of civil action. Action brought to enforce, redress, or protect private rights. In general, all types of actions other than criminal proceedings, right? Because that's still going to be common law. But guess what? Now, even technically, criminal law is taking place under civil jurisdiction because all the courts are equity court. You're going to read right here. Says this term includes all actions, both those formerly known as equitable actions and those known as legal actions. So equitable actions, enforcement of contract, there is a judge. Legal actions was at common law, right, with a jury, and the magistrate is separate from the tribunal, being the jury, and does not decide the facts of the law or the case. So it says, so the term includes all actions, both those formerly known as equitable actions and those known as legal actions, or in other phraseology, both suits in equity and actions at law. See, they're separate. Like Article 3, Section 2 of the federal Constitution says the judicial branch of government shall have jurisdiction in all cases of law and equity. So it makes a distinction between the two. But see, what they're telling you here, what Black's Law is telling you here, is that they've abolished the distinction. Well, how can they do that? Well, they can only do that if they've actually removed you from having the ability to use common law by, say, infancy, right? Placing you under presumptive administration, and then, applying civil code to you and removing your ability from using common law. Does that make sense to you guys? If not, let me know in the chat. So, the term includes, so it says both suits in equity and equity at law. It says in the great majority of states which have adopted rules or codes of civil procedure as patterned on the federal rules of civil procedure, there is only one form of action known as civil action. Well, what happened to common law? See, they can never remove common law or abolish it like they keep trying to say, because it is the default jurisdiction. Being as the people are sovereign, Chisholm v. Georgia, right? Being as the people are sovereigns without subjects, they must have contracted their rights away. Okay, they must have contracted their sovereignty away in order to be removed from the default jurisdiction of sovereigns, that being common law, and being placed under civil law with no access to common law. They cannot abolish common law, but what they have done is created a web of contracts so thick that they felt comfortable in removing any common law venues because there was no one left in the nation capable of using them, or even knowing how to use them. And that's what they actually did. The former distinctions between actions at law and suits in equity and the separate forms of those actions and suits have been abolished. Well, how could they be abolished when they're still in the federal Constitution? The distinction's still there. So they're not abolished if you know of them and you know how to raise that question of jurisdiction and challenge jurisdiction. The only way that you can be drug out of common law jurisdiction into equitable jurisdiction, right, either the enforcement of trust or some form of contract, is necessary. So there has to either be proof of presumption, like your idiocy, lunacy, infancy, drunkard, spendthrift, whatever, right, that has allowed the state to take control of your estate and administer you as non-compos mentis, or mentally incompetent. Then you can be in equity, but even asking the question for them to prove that shows that you're not incompetent. So they're not even going to venture to try to say, oh, well, we're administering your estate. So then you say, okay, well, where's the contract that has me in this court of equity? Because that's all a court of equity is the enforcement of contracts and agreements, or the enforcement of trust law, right? Code's the administration of infants. So I like how they use the word abolish. They can't abolish common law. So what they mean by that is they've removed the knowledge of common law and how to use it from the majority of the public, and they felt comfortable enough to remove the common law venues, or because you can still file a suit at law. That's the whole point. They keep using that word abolished, even though it's impossible for them ever to abolish it, because that is the constitutional law of the republic. And they could never abolish it in England or Canada or any other common law country that was, colonized by England. No more than they could abolish it in England itself. They can never abolish common law. It is the default jurisdiction. It's the law of nations. That's actually what they call it. So this new Admiralty international law is new compared to the old common law of nations. That's what Blackstone refers to it as. That's what Bouvier refers to it as. It's the law of nations. So we're going to take a look at some of this other stuff here. I want to show you that it's not supposed to be in our republic. And I'm going to move through this stuff pretty quickly because, like I said, I'm pretty tired. But if you guys have questions, let me know. Let's see here. Jerry, son of Mick, says, and they may have jurisdiction to hear such cases, but does it apply to you? No, unless you fall for it. Exactly. So, here, let's see, where was this? Okay, so what it says is, okay, the author was induced to believe that. So what inspired John Bouvier to write this dictionary? And this is actually the very first one from 1854. This is an 1856. No, this is the second edition. I'm sorry. First one was from like 1840 something, but this second edition. And actually, I'm going to link in the chat. You guys tuned in on a good day because I happen to have this open. I'm going to link in the chat a list of dictionary. This is resources. All these dictionaries are on a PDF drive, and you guys will now have access to all of these dictionaries. And I advise that you download the Bouvier's ones for sure, and whatever other ones strike your fancy. But Bouvier is the most important. So, Ida Hat, good to see you. I'm glad you can make it. Let's see here. Bam. So you guys have access to all those dictionaries. That is an invaluable resource. Have I looked into those airline incidents? I've heard of them, but I've been so focused on this stuff recently that I actually haven't been. I know they're intentional. I mean, obviously, like, how does a helicopter hit a plane? That doesn't even make sense, especially with as much time as it had to move out of the way. For what purpose are they doing this? I don't know. It's psychological operation, try to throw the country off. I honestly have no idea. Or, okay, so honestly, the thought that popped into my mind since you brought it up was, what if these are fifth generational warfare attacks, right? And the reason that they're not coming out and publicly saying that's what's going on is because they don't want mass panic. But if we're actually being attacked from the inside, is one that I could see that happening in response to, basically the destruction of globalist agendas. At least on the surface, it appears that way. So I always, am wary of government in general. And I'm definitely not a statist, but it does appear that, the whole climate thing's being undone and the whole WHO and all that. But we'll see. We'll see. Anyways, back to this stuff. So you guys have a good law dictionary. Yeah. So yeah, that's one. I think it's an attack. That's my personal opinion. I think it's an attack. But anyways, so back to Black's Law, or the other Black's Law, or Bouvier's, I'm sorry. So the author so what inspired John Bouvier to write this was, up until this time, there had not been a dictionary specifically written and adapted to the laws in the Constitution of the United States, which was purely common law with and equity, with some equity in there, but it's primarily common law. And that, when you read these dictionaries, you see that. In fact, I believe the full title of the dictionary is the Law Dictionary adapted to the laws of the laws in the Constitution of the United States with references to civil and other forms of foreign law. So civil law is foreign law because it's Roman civil law. It's Roman law. It's Roman civil law. It's not English common law, and it's damn sure not American common law. So it's foreign. So he wrote this because there had not been a law dictionary specifically adapted to the Constitution. And so the way he's writing this, you'll see, he says the author was induced to believe that occasional comparison of the civil canon and other systems of foreign law, it says right there, here, I'll put it at the top of the page since I can't highlight it. So it says that the author was induced to believe that an occasional comparison of the civil canon and other systems of foreign law, foreign to the United States. We're not supposed to be under civil law. So what's this one form of action horseshit, right? With our own. So civil law is not our own law. John Bouvier, in his law dictionary specifically made for the laws in the Constitution of the United States, is telling you that civil law is not our law right here. Okay? Just so that's clear. Can you guys see that? All right. It says, would be useful to the profession and illustrate many articles which, without such aid, would not appear very clear, and also to introduce many terms from foreign laws which may supply a deficiency in ours. The articles of condonation, extradition, and novation are of this sort. He was induced to adopt this course because the civil law has been considered, perhaps not without justice, the best system of written reason. And as all laws are or ought to be founded in reason, it seemed peculiarly proper to have recourse to this fountain of wisdom. But another motive influenced this decision. One of the states of the Union derives most of its civil regulations from the civil law. That would be Louisiana. It's the only state, because we bought it, the Louisiana Purchase, Jefferson bought it from Napoleon, and it was under civil code under Napoleon, which is Roman civil law. And here he takes it says, where were we? Yeah, so, yep. Therefore, introducing it into the American Law Dictionary. He also had the example of a story, a Kent, Mr. Angel, and others who have ornamented their works from the same source. And here he takes the opportunity to acknowledge the benefits which he has derived from the learned labors of these gentlemen. So my point in showing this is that we're not, civil law is foreign to our government, our system of law, period. We're not supposed to be under civil law. It is not supposed to be. And now another note to that is that the attorney, the bar pirate, can only operate in civil law, right? I mean, he can practice at law, but it's not exclusively secreted away to the attorney, because common law is the law of the laity. That's actually why the clergy were forced to stop teaching or stop learning it and stop practicing it, because it didn't conform to the constitutions of the Catholic Church or whatever, and it was the customs and practices of the English laity. And so the Pope was like, yeah, you guys don't do that anymore. But before that, it was primarily the clergy that studied and practiced common law as well. And we'll get into that a little bit. Actually, we'll get into that right now. Let's go over here. So this is interesting. So we're learning a little bit, like, so I'm reading through Blackstone's. This is volume 1, and it's fantastic. Blackstone's commentaries. And this is what the founders read. This is what the colonists had in their houses, along a copy of this and a copy of the Holy Bible were required reading, right? Especially for jurists. And I'm reading through this and I'm getting a picture of the history and the battle between Roman civil law and common law. So the history of nations throughout the last 1,000 years have literally been, especially in the Western world, the story of a battle between two parallel systems of law. One is common law based on natural law and divine law that was largely unwritten. In fact, it was considered an abomination to write it prior to the Magna Carta. And then even after the Magna Carta, it still remained unwritten and was preserved in case laws handed down by the various common law courts in England. And then the other law is written law created by man called Roman civil law, where it's the enforcement of private conscience and contracts. That's so when you think of the word statutory or civil law, if it does not conform to common law, then it is the enforcement of a man's private conscience, or a group of men and their private conscience upon another man or woman. And because of that, it requires your consent to be under it. Therefore, you have to be under contract. And the only caveat to that is presumption, where they can administer your estate. They can take your estate under administration because you're considered incompetent. That's the only time you don't have to actually knowingly and voluntarily consent to be under statutory law. And that's why they chose to use probate created by the Magna Carta, or infected into common law by the Magna Carta, to presume everybody's incompetent and administer their estates, and then sheet it to the well, immediately once you became a 14th Amendment citizen and accepted benefits from the government, you were considered incompetent. And people have to understand that's an ancient maxim of law, beneficium abstinende, is that he who accepts the benefit foregoes the inheritance. And so, or abstains from being the heir. Abstinente is abstains from being the heir. And the reason I bring that up is because essentially everything is trust law, like everything. It all goes back to trusts. And so common law is when you have complete control over your own estate and it's not under administration. And then that's why I call common law the law of sovereigns. Then it's just one sovereign dealing with another. But as soon as you start to get into any kind of administration or where the government is a parent, everything is trust. Well, the word administration is purely a trust term, but everything becomes trust law once if you're indentured in any form or fashion. The way that you become indentured is by accepting a benefit. So like Dylan says, yes, they're using statutes and codes to make common law obsolete. And there's a couple caveats to that. So if I can find my damn mouse, there you go. Let me put so they're using common statutes and codes to make common law obsolete. It's sort of like that. But see, we still had statutes in this, in the Republic with common law, right? But the statutes had to conform to common law. And that way it was applicable to everybody, whether you were under contract or not to abide by the statute. Because if the statute says do not kill anyone, well, then you can't kill someone and be like, oh, that's a statute, because that also violates common law. Does that make sense? So that's why the statute, that's Marbury versus Madison, says any law repugnant to the Constitution is null and void. That's what that means, because the term law used back when James Madison would have been in court with somebody, the word law only meant common law, as we just seen from Bouvier's dictionary, because all other systems of law are foreign to our republic. So anything that's repugnant to common law is null and void. But what happens, Dylan, is under presumption, they've taken control of your estate, because when you became a 14th Amendment citizen, when your parents abandoned you by documentation with the birth certificate, the state pledged you to the federal government. Well, actually, your parents just signed you right up with the Social Security card and all that. So you became a 14th Amendment citizen, and you immediately began to receive benefits in the form of deferred retirement payments, right? Which would be the Social Security account. That immediately makes you incompetent, makes you an infant, because you can't plan for your own retirement, not to mention all of the other benefits, public schooling. And that's why we have a system of benefits. And everybody, if you listen to all the policies that the administration's always talking about, it's always about, we're going to give people this, and we're going to do this for people and do that for people. In a free society, the government doesn't do a fucking thing for the people, because as soon as you accept something from anybody, but especially the government, then you're incompetent under common law. As soon as you need government assistance to live, you are no longer the master of your house or the executor of your estate, the owner of your estate. That's it. Because you can't take care of yourself. So automatically you come under whoever is giving you the benefits. And that's how they've done it, through the 14th Amendment. But they were doing it even before the 14th Amendment, just through the state probate courts. And they were escheating all the poor people's property, right? They'd have overseers of the poor here in Michigan, and they'd take all the poor people. As soon as the poor people went to the overseers of the poor for some benefit or some form of charity, then they could immediately take that person under administration. And that's how they've done it. And then the 14th Amendment was the nail in the coffin, because 14th Amendment is nothing but benefits. Okay, even your rights that you had naturally endowed upon you by your creator, as per most Bill of Rights and the Declaration of Independence and everything, just the common law understanding, you already had those things. But what happened when you went and contracted with the federal government for deferred retirement benefits and to have your rights secured as privileges? Now you're basically going to the United States as like a mob boss and asking them for protection. I want you to protect my rights. Now you don't have rights, they're privileges. Civil rights are not rights, they're privileges granted by the government, which can be taken away by the government. And so that was a big scam too. You basically went and signed up for something you already had. Now, the way that they work that in there is the same way they, is racial division, saying the newly freed slaves don't have any rights under the Constitution. Well, they didn't have any rights under the Constitution, not because they were black, but because they were slaves and they weren't actually freed properly, first of all. And secondly, they didn't know how to operate in society as free men. That's why. And Andrew Johnson even said something to that effect, that in time they could learn to be free. You don't have to grant them privileges with the 14th Amendment and usurp the rights of the states. Like, these people can learn to be free men in time. And so that's another great deception in history, is telling you that black people couldn't have rights because they were black. That's not true at all. It's because they did not know how to operate in society generally. And some of them did. In fact, there were some black owners of, so that's the whole thing. History is a bunch of bullshit, and it must necessarily be so in order to get you to be a docile slave. Anyways, so the 14th Amendment is nothing but accepting benefits, and that's why you're immediately an infant, according to Title I, Section 8 of the United States Code, that in any act of Congress, the words human being, person, and individual all mean infant. So anytime you see the words person, human being, or individual in any United States code, you immediately know they're talking about an infant. And infants cannot hold title, nor can they sue or be sued except in the name of their guardian, which is why you're always taken as a resident in your state. So the municipalities in the state can sue you in the name of your guardian as a United States trustee, as an agent of the United States. And that's the only way they can sue you as an infant. So shit gets deep. Yeah, don't dwell on the writings of Esquires. Yeah, so it is simple, but see, if you're just popping in here, it's a lot more complicated once you don't have the rights protected because you're presumed to be an infant or some form of incompetent. Then you have no rights. And that's kind of what I was explaining to Dylan, is so there's only two ways you can end up outside a common law jurisdiction, being drugged into the inferior jurisdictions. One is to agree by contract, or two is to be taken under administration by presumption through probate. And they chose the latter. And that's what they've done to everybody, is taken them under administration through probate, because you're accepting all these rights and benefits, or all these privileges and benefits from the corporate United States. You're signed up as a franchise of the corporate United States, and as an agent of the corporate United States, and as personnel of the corporate United States. So you are an infant. And so the common law is not available to you until you know how to claim it and use it. And that's the point. So you kind of have to understand at least that much about the writings of Esquires. Yes, Rem, it is a con. And in fact, the Constitution, was a subversive document written against the will of the people, behind closed doors, with armed sentries outside the convention. Nobody was allowed to know what was being discussed because it was being written by attorneys. And that's the whole point. The attorney is your enemy. The attorney is the enemy of all mankind. And we're going to get to that. But they can only operate exclusively in civil law. They can practice at law, but they're no better. You can also practice at law as well. But when it comes to practicing in their civil law and their commercial law, you have to have a license, right? So they occult away both the ability to practice that law and a lot of the knowledge of it, right? Unless you're diligent like I am and others are, and you guys are, and you're willing to actually go read and learn the language of Esquires, because it is necessary. No jurisdiction exists independently either. While common law is the law of the republic, if you wanted to do international trade or ship stuff over to England or receive stuff from England back, you had to know admiralty, right? You had to know admiralty law, international law. And so, there is, and then again, equity has always existed in this country as well. And so it's either suits at law, which are legal, determining crimes and harm, or suits in equity, enforcing contracts. But see, trust is also enforced, and trust law is also enforced in equity as well. And so equity is technically chancery, and that's a spiritual court. And that's where we're going to, that brings us to where we are right now. So it says right here, it says, and since the Reformation, many causes have, this is Blackstone's commentaries, if you're just tuning in. And this actually gives us a little history about the battle between common law and Roman civil law, because it has been a battle between those two streams of law, and common law almost lost a long time ago if it wasn't for one article of the Magna Carta, which is what we're about to read right here. So it says, and since the Reformation, many causes have conspired to prevent its becoming part of academical education, which is common law, is what he's talking about. As first, long usage and established custom, which is, as in everything else, so especially in the forms of scholastic exercise, have justly great weight and authority. Secondly, the real intrinsic merit of the civil law, considered upon the footing of reason and not of obligation, which was well known to the instructors of our youth, and their total ignorance of the merit of common law, though it's equal at least and perhaps improvement on the other. But the principal reason of all that has hindered the introduction of this branch of learning is that the study of common law, being banished from hence in the times of popery, has fallen into quite different channel, and has hitherto been wholly cultivated in another place. But as long usage, established custom of ignorance of the laws of the land begin now to be thought unreasonable, and as by these means the merit of those laws will probably be more generally known. So basically what he's saying is he's talking about the war between common law and civil law. So we'll pop over here for a second. You'll see that this is a little history of the temple, the Middle Temple, which is one of the Inns of Court, which I've explained to you guys before, but there's 4 Inns of Court, and 2 of them are actually in the Temple Church, and that would be the Middle Temple and the Inner Temple. The other 2 are Lincoln's Inn and Gray's Inn, and they're actually a form of secret society. They're unincorporated so that they can't be taken to court or sued or have to produce any kind of public documents or anything like that. And in order to be a barrister in England, you actually have to be called to the bar by one of these Inns of Court. And so this is where this stuff comes from, right? It says, during the 12th and early 13th centuries, the law was taught in the city of London primarily by clergy, but a papal bull in 1218 prohibited the clergy from practicing in the secular courts, meaning worldly courts, where the English common law system operated. And so that's what Blackstone is talking about over here. He's saying that that's primarily what started to, that created the ignorance of the attorney of common laws, the fact that they were actually barred, the clergy was barred from being able to practice it or learn it, right? And so he said, for being then entirely abandoned by the clergy, a few stragglers accepted the study and practice devolved, of course, in the hands of laymen, who entertained upon their parts a most hearty aversion to civil law. See, the laymen, the regular common, for they hate civil, just like we do, right? And made no scruple to profess their contempt, nay, even their ignorance of it in the most public manner. But still, as the balance of learning was greatly on the side of the clergy, and as the common law was no longer taught as formerly, this is how it almost burned out. This is how they almost conquered common law. In any part of the kingdom, as formerly in any part of the kingdom, it must have been subjected to many inconveniences, and perhaps would have been gradually lost and overrun by the civil, a suspicion well justified, from the frequent transcripts of Justinian to be met with Bracton and Fleta. See, now this is important because he's showing you this is a war between the civil and the common law. And this is written from the perspective of England. So Blackstone, this was before these commentaries were written, before the United States was a nation. It was still colonial, right? And so he's writing about English common law and civil law's role in England, okay? He even writes in another part about it barely surviving the Norman conquest, and that was the whole point, because prior to the Norman conquest, the English were self-governing, right, under common law, and the law was never written. It was recited regularly at get-togethers called things, and I think Wigamawo, or that might have been the Nord, but they had these regular get-togethers in what were called hundreds, where it was basically like an incredibly large neighborhood, and all the men got together in a council called a hundred court, and they would deal with issues amongst that small area, and it was all self-governing. Well, when Norman the Conqueror came over, who was under Roman civil law, he brought that civil law with him, and he couldn't have any self-governing or property rights. So he forced everybody to register their property, and he split the courts, and everything dealing with life, death, inheritance, trust, and estate was given to the clergy. And then, of course, then he left the secular court to, the clergy also ran the secular court as well, until the Pope banned the clergy from being able to practice common law. And then it devolved, like Blackstone said, back to the laity. So anyways, and he said that it was almost overrun by the civil. And see, so when this republic was created, the United States, there was no civil law in this country. We said, fuck that. It's all common. It's all the law of the laity, right? And because we don't have kings, royalties, or any kind of pope or priests over here, this is all just everybody's sovereigns without subjects. Like Chisholm v. Georgia from 1793. That's what I was talking about. I think it's 1793. The one I showed on the last stream. So if you're just tuning in for the first time, go watch the last stream and you'll get a look at that case, because I just do not have time to pull it up right now. But anyways, he said it would have almost been overrun by the civil law had it not been for a peculiar incident, which happened at a very critical time and contributed greatly to its support. The incident, which I mean, was the fixing of the Court of Common Pleas, which is from an article in the Magna Carta. The grand tribunal for disputes of property to be held in one certain spot, that the seat of ordinary justice might be permanent, notorious to all the nation, formerly that in conjunction with all the superior courts was held before the king's capital justiciary of England, and the Alla Regis, or such of his palaces wherein his royal person resided, and removed with his household. Blah, 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 blah. Right. So basically what he's saying, he said this was found to occasion great inconvenience to the suitors, to remedy which, so he's saying to have to chase around the king and the king's court, or one of his Alla Regis, right? Or one of his justices, was a pain in the ass. So it was put in the Magna Carta for that exact reason, that the common pleas would be held in one place, so we don't have to chase the king around. And because the king was the sovereign in England. The barons were technically sovereign above everyone else, but under the king. That's why basically how I explain it to people is, in the United States, we're sovereigns without subjects. We're basically like all barons without a king, or you could just say we're all kings. And so we operate under common law with the law of sovereigns, the law of freemen, right? So the article in the Great Charter of Liberties, both that King John and King Henry III, that common pleas could no longer follow the king's court, but be held in some certain place. And because of that, that saved common law, and it also created a long history of jurisprudence and case law of common law. Because remember, common law is still not written down, and the reason it's not written down is because it's natural law based on divine law, based on the Bible. That's exactly, and whether you like it or not, that's what it is. And that's why in the Magna Carta, the first thing they did in order to have all these rights secured was to make their church independent. Again, because all law is practiced and administered by the priest class generally. Okay. And that's because all law is, and even equity or civil law is supposed to be meritorious and biblical. And that's why it's considered a spiritual court. So, civil law courts, chancery, which is what equity is now, is essentially a spiritual court. There's a little bit of a difference, but that's why the judge wears a black robe, and that's why he's under judicial canon and all that stuff. So yeah, anyways, that saved common law. And then we're going to pop over here. Let's see here. What was I going to show you guys over here? Hold on. 1 second. Okay. So these three different types of law, right? So it says law, in its most general and comprehensive sense, signifies a rule of action prescribed by a superior to an inferior being. That's it. That's the substantive definition of law. So if we're the people, we the people created the government here in the United States, right? We are the superior being, and the creation is the inferior being. Because if it's the other way around, that's like man telling God what to do. It's the same reason why the government can never declare you sovereign, is because that's like you telling God he's God. It's the same concept, right? So it's a rule of action prescribed by a superior to an inferior being, and is implied indiscriminately to all kinds of action, whether animate or inanimate, rational or irrational, right? So that's why the king's court, right, was before the Magna Carta. That's where common pleas were held, because he was the superior being in England, right? But we don't have that here in the United States. So, yes, all is mind. Somebody read the Kabbalion, huh? Law comprises the law of nature, revealed law, the law of nations, and municipal law. So when you read these old books like Blackstone's and read old common law books from like the 1700s, the law of nations is common law. Okay. That's why it comes before the municipal law. So it goes, the law of nature is the will of our maker. It says the reason it's called the law of nations, because all nations practice common law at one point in time, which is one thing. They've hidden that from history as well. And it makes you wonder, like, how did all nations practice common law at one point in time? At least according to these jurists, that was the case. Maybe all the nations they knew of, I'm not really sure. But anyways, the law of nature is the will of our maker. For God, when he created man and endowed him with free will, not only laid down certain immutable laws of human nature, whereby that free will is in some degree regulated and restrained, but he gave him the faculty of reason to discover the purport of these laws. And he has so intimately connected, so inseparably interwoven the laws of internal justice with the happiness of each individual, that the latter cannot be secured but by observing the former, meaning it's written on your heart. Right? So that's what he means, but he's so inseparably interwoven the laws of eternal justice with the happiness of each individual, means it hurts generally, unless you're a sociopath or a psychopath or an inbred rich greedy oligarch, right? You generally feel bad when you hurt somebody. That's because injustice hurts your heart, right? And the laws of eternal justice is tied to your happiness. So when you violate the laws of eternal justice, it makes you unhappy. That's what Blackstone's saying, one of the most well-respected jurists in the history of law, where every colonist had a copy of this. This book single-handedly was one of the biggest inspirations for the creation of this republic. And so, yeah. So, let's see. Divine providence has been pleased at sundry times and in diverse manners to discover and enforce his laws by an immediate and direct revelation, which we call divine or revealed law. So this is the next type of law, right? These laws are to be found in the Holy Scriptures, and upon the law of nature and the law of revelation depend on all human laws. So saying all laws are supposed to conform to the law of nature and the law of revelation. That's why these satanic assholes have taken you into just law of contracts, commercial law, just the enforcement of contracts, so they could remove the spirituality from it, to remove the fact that it's supposed to conform to divine law and natural law and revealed law, and basically just make you a materialistic consumer, right, devoid of any kind of purpose or meaning, and that makes you a much better, more docile slave. That's why I tell everybody that communism must have its citizenry be atheists and its leaders be Satanists, because you have to be hella evil to do that type of shit. The law of nations is what's termed international law, a law to regulate the intercourse of nations, the offspring of civilization, a moral obligation of justice and humanity from one state to another, and which entirely depends upon mutual compacts, treaties, agreements between the several communities. Now, I need to expound on this, because when it says one state to another, when you're like, we the people, and like back during the Northwest Territory, like the times when we had like in the early 1800s, late 1700s, you yourself are a state. So what he means by this is one state, one e-state dealing with another e-state, a state, right, entirely depends on mutual compacts, treaties, and agreements. It's the law of sovereigns. And so what this is common law. The law of nations, the law of sovereigns, and that's what he's saying. Justice and humanity, a moral obligation of justice and humanity from one state to another, which entirely depends on mutual compacts, treaties, and agreements between the several communities, right? So this is the same for two families, two households, for the representatives of those households. That's it. That's how our republic was set up. So municipal law is a rule of civil conduct. There's the civil, right? And this is where you start getting into statutory law, commanding what is right, prohibiting what is wrong, and regulating matters in themselves indifferent. So the difference with this is it doesn't necessarily have to conform to divine law necessarily, because say it's indifferent is what he means. So to say, like, well, he gives an example, I'm pretty sure down here. That's a pretty good example. Where is it at? It's down here. So forms of government. Where was it? Because he had a good example. Right or wrong. So, okay, what are the duties of government? One of the duties of the supreme power is to make laws, the other to prescribe the rules of civil action, commanding what is right, prohibiting what is wrong, regulating matters in themselves indifferent. Now, in order to do this completely, it is first of all necessary that the boundaries of right and wrong should be established and ascertained by law. Now, what he's talking about in the civil action, which is all the government really deals with, right and wrong doesn't mean necessarily morally right or wrong. It just means, is it right or wrong when applied to society? Okay. So it says, in what manner does the law ascertain the boundaries of right and wrong? Explain the method it takes to command the one and prohibit the other. Every law consists of several parts. One, declaratory, whereby the rights to be observed and the wrongs to be avoided are clearly defined and laid down. The other, directory, whereby the subject is instructed and enjoined to observe those rights and to abstain from the commission of those wrongs. A third, remedial, whereby the method is pointed out to recover a man's private rights to redress his private wrongs, right? So those are the three parts of a law. It clearly establishes, directs you how to observe the rights and abstain from violating, what they said is wrong to violate. And if you are violated, there's a remedy provided. So a law must have those three parts right there, is what he's saying, right? And with regard to the first three, the declaratory part of the municipal law, this depends on the wisdom and will of the legislature. For those rights which God and nature have established, called natural rights, such as life and liberty, need not the aid of human laws to be more effectively possessed by man. That's why man does not write laws. That's why common law is not written. That's exactly why common law is not written. The only thing that's written about common law is the wisdom of the jurists, or the juries rather, who have decided the case, which is a collection of sovereigns. And then they say this is how this was decided. On the contrary, no human legislature has the power to abridge or destroy them, unless the owner shall himself commit some act that amounts to a forfeiture. So this would be like getting a felony, right? A felony conviction will leave you what's called civilly dead. But actually, on that note, if we head back over here to Black's Law, there was something else I wanted to show you in the definition of civil death. So it's civiliter mortis in Latin, it is called. And as a 14th Amendment citizen, you are civiliter mortis. And I'm going to show you why and how. First of all, because anyone who's bankrupt is civiliter mortis. That means you've lost your rights or your ability to have rights. Okay, so the state of a person who has, though possessing natural life, has lost all civil rights, which we don't have civil rights unless you're a 14th Amendment citizen. You have common law, right? Natural rights. Civil rights, as to them, is considered civilly dead, right? And so in some states, persons convicted of serious crimes are declared to be civilly dead, which means that certain civil rights and privileges of the convicted offender, including the right to vote and contract and to sue and be sued, are forfeited. Okay, that sounds fair, right? If you felony or whatever, right? So let's check this out. A corporation which has formally dissolved or become bankrupt, leaving an estate to be administered for the benefit of its shareholders and creditors, becomes civilly dead. So what do? They presume you, the state citizen, one of we, the people, are dead or missing because you've never claimed your estate within the first 7 years of your life. You've never expressed your will. So you're dead or missing as one of the people. Now, the 14th Amendment's trustee, infant trustee, is part of a bankrupt corporation. He's a franchise, right? Or she is a franchise. And the estate is being administered for the benefit of the shareholders of the United States and the creditors of the United States. So you are actually the trustee of a civilly dead estate. And that is another reason that the judge wears black. Does that make sense, guys? So good to see you make stupid people famous. Glad you made it, man. Also, good to see you as well, Peaceful Penguin. Incarnate Unlimited, good to see you. I'm sure some people have popped in here since then. Sorry if I didn't say hi to you. But anyways, back to Blackstones. This Blackstones, economists. So it says no human legislature has the power to abridge or destroy natural rights or natural law, right here. It says, so for those rights which God and nature have established, called natural rights, such as life and liberty, need not the aid of human laws to become more effectually possessed by man. On the contrary, no human legislature has the power to abridge or destroy them unless the owner shall himself commit some act that amounts to a forfeiture. Now, not just a felony amounts as a forfeiture, but a bankruptcy would also amount as a forfeiture, and also being incompetent and coming under administration amounts as a forfeiture, like say you're a drunkard or a spendthrift or something like that, and also accepting a benefit because you cannot take care of yourself or your family is a forfeiture of your natural rights. This is literally hundreds and hundreds of years of jurisprudence, and that's the thing about common law. It has stayed the same all the way back from the Magna Carta to when you read the Northwest Ordinance of the territories of Michigan and Ohio and Illinois, that it is the same. It's the same exact law, the same exact wording, the same exact attitude towards property and inheritance and everything. It stays the same, right? Because it's not, we didn't create it. We didn't write it. We just observe it. We observe it and we follow it. And that's what common law is. That's why I always tell people, unless you understand that there's a creator and you understand that authority flows down from the creator to mankind, and that mankind are all co-equal under God, right? And that we're endowed with unalienable rights, just like it says in the Declaration of Independence, just like it says in the Virginia Declaration of Rights, the Illinois Declaration of Rights. Again, the same wording, same concepts, right? The only way you can come under another man, like Cruden v. Neal, it says that all men are independent of the institutions of their fellow men, absent consent, right? They're not bound by the institutions of their fellow men, absent consent. You have to contract. Well, the one thing they never teach you is you can also be presumed under that as well, either by accepting a benefit or being incompetent, or both, which, because accepting a benefit is a form of incompetency. So unless he commits some act that amounts to a forfeiture of his natural rights, it's the only way, right? The case is the same as to crimes and misdemeanors that are forbidden by the superior laws, and therefore, see how he calls them the superior laws? Yeah, so if an inferior law does not conform to the superior laws, and they used fraud, coercion, or collusion to pull you under that inferior law, then that is null and void and doesn't apply to you. Okay, let me make sure I'm not missing any questions. So anti-whiteism says, I don't see how any of this constitutes consent when it's all achieved by deception and orchestrated ignorance. It seems Luciferian and voided by the virtue of, Yeah, fraud. So it is when you claim it, you have to call it out though. See, but because nobody ever actually expresses their will, remember this, all of this comes back to free will. The very essence of law and property is your will. You don't just have a will before you die. That's just your last will. That's the will that carries on after you have ceased to breathe. Okay. You express your will throughout your life, or you do not. And if you have never expressed your will, then you're presumed not to have one. So yes, it's fraud, and it's dirty because they never taught you. So it's not so much that they've tricked you, which, well, no, they've tricked you, but they just never taught you. They took the knowledge away from your parents and your grandparents and your great grandparents successively over the course of generations, and then just made sure you never knew about it until they got to a point where they were comfortable with abolishing common law venues, which they can't abolish common law, right? They can just be like, nobody's using it, so we don't really need these anymore, right? Because nobody knows about it, and we've successfully occulted the knowledge of law away because we're a bunch of filthy bar pirates, right? So, yeah, that's pretty much that. Let's see here. No additional turpitude being declared unlawful by the... Yeah, okay. So, but with regard to things which are said to be themselves indifferent, this is the example I was looking for earlier of like municipal, of how like right or wrong is a statute or code that doesn't necessarily violate common law, but isn't a replica of it because it's so indifferent, so unique to societal organisms. Just here, let's read it. So these become either right or, it says, but with regard to things which are said to be in themselves indifferent, the case is otherwise. These become either right or wrong, just or unjust duties or misdemeanors according as the legislature enacts for promoting the welfare of society and more effectually carrying on the purposes of life. But still, those things cannot violate common law. Thus, by our own common law, as at present interpreted, the goods of the wife do instantly upon marriage become the property and right of the husband. And our statute law has declared all monopolies a public offense. Okay, yet that right and this offense have no foundation in nature, but are merely created by the law for the purpose of civil society. So those are essentially statutory laws. Those are the enforcement of private conscience by consent and agreement upon everybody else, or, that everybody else gives consent and agreement to, yeah, we all agree that this is law, because it's not based on the laws of nature, but it's how that community, that society decided that they want their society to operate, if that makes sense. So infants knew right. What do you mean in Rem? Infants knew right from wrong. Early education included. Whose early education included law? Mine didn't. You have the natural law. That's what he means. That's what Blackstone means by he has inseparably interwoven eternal justice with the happiness of mankind. Is that right from wrong from the time you're a child. If you push somebody over and take their toy, it's wrong because they cry and you feel bad, and that's what they mean by common law. Doesn't need to be written down. Unless you're an inbred sociopathic corporate oligarch, right, that loves money more than anything in the world and wants to enslave everybody, then maybe you don't have that because you're from a bloodline of satanic pieces of shit. I don't know. But anyways, so that's kind of what I wanted to go over on jurisdiction this morning, where that's really all the time I have for it. What I want to do before I get off here is I want to show you guys that these bar attorneys were never supposed to be here, which is how you know that it was actually authentic, that we are all sovereigns without subjects, and that we've been infiltrated and subverted by the bar pirates. Because the original 13th Amendment, this is what they want you to believe, that this was mistakenly ratified. Okay, that this wasn't actually, or mistaken as ratified, but never actually was. And so they want you to think that all these learned, people back then went around for literally over 2 decades thinking that the 13th Amendment was ratified when it actually wasn't. Or what's more likely is the bar attorney finally got into power around the 1830s. The bar pirates finally got into a position of substantial power in the 1830s and were able to remove this through deception, right? And so this right here, Article 13, if any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall, without the consent of Congress, accept or retain any present, pension, office, emolument of any kind whatever from any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States and shall be incapable of holding any office of trust or profit under them or either of them. What is esquire? Esquire is a title of nobility. It's above a nobleman, or above a gentleman, but below a knight. Okay, so it's a title of nobility. It's actually the shield bearer of the knight. So I find that interesting, especially given that all the esquires are basically from the old Templar building in the city of London, right? And that the esquire is a shield bearer. That's where the International Bar Association is, right? So this is, oh, you're saying, yeah, before 1900, absolutely. But still, they started removing it, the knowledge of the law. That's how they were successful in being able to, and not in every state either. Like Michigan set to work right away as soon as they became a state, before they even became a state, making the people stupid by creating public and schooling institutions and universities to take control of the education. Because Michigan was founded by an exceptional form of scumbag, in my opinion. Like the most wretched, slimiest fucking bar pirates on the planet started in Michigan. And you can tell when you start reading their old laws and the way that they immediately grandfathered probate in. I despise whoever just started Michigan. They're just fucking scumbags, dude. But anyways, this is from the Revised Statutes of Virginia, 1819. So I've got another one for you. This is the Laws of the Territory of Michigan from 1827. Yeah, 1827. And boom, there's Article 13. If any citizen of the United States, here, we'll hide the controls, zoom in, right? Well, I suppose we needed the controls to zoom in. So you guys can see it's actually right there. Now we'll hide the controls. If any citizen of the United States, so two different books, almost 10 years apart from each other, but it was a mistake. So you're telling me all these learned jurists and lawyers, right? All these people, they were just mistaken for decades. Because I'm pretty sure, if I remember correctly, it was ratified in like 1809. So you're talking almost 20 years. This went around and was just, everybody accepted it as ratified. Like you can't hold an office if you're an esquire. You can't even be a citizen of any of the states if you're an esquire. You're a foreigner because you have a title of nobility from a foreign power, right, over there in London, which is its own sovereign city-state. So you're ultimately under Rome, right? And that's where Roman civil law comes from. It comes from the fucking bar attorney. He wants Roman civil law because that's where the attorney gets to be God, whether he's a judge or he's just an attorney sitting in the place of judge, right? He gets to be God. That's the whole point. And they're really undertakers, is what they're soul reapers. That's what they're doing. But we'll get into that another time. So I wanted to show you that. Now let's go through how there is no money in this country. And in fact, I almost want to save it till next time because this is an entire show in itself. But I'll give you guys a little preview. How about we do that? So here I have some Supreme Court case. Well, first, this is the Credit River decision. Now, this is funny. This guy, his name was Jerome Daly. And he was an attorney, okay? And this is from the Scott County in the state of Minnesota, and it's a very hard case to find. You'd almost have to go down there if you want the original copy to Scott County, because like I said, the judge was killed after, well, I don't know if we're on YouTube, so he was unalived after this decision, and so were some of the jury members. But what had happened was, the guy Jerome Daly, he was an attorney when Nixon, this case took place in 1969, right after Nixon took us off the gold standard. This guy had just gotten a mortgage on his house, right? And as soon as we were taken off the gold standard, being an attorney, he knew what that meant. And he said, well, wait a minute. I'm putting up my house. What's the bank putting up? They're not putting up anything, right? It's a promise to pay does not constitute payment. And that's all we have is promises to pay. All we have is debt secured by your sweat equity, the mortgage of your estates, like we go through all the time. March 9th, 1933, page 83, second paragraph on the left-hand side says the money represents a mortgage on all the homes and all the other property of all the people in the nation. So it's the mortgage of your estate, which essentially means the mortgage of your property rights. And that's all the dollar represents. It's a contract signed by two parties, the Secretary of Treasury and the Treasurer, representing two parties of a contract because the Treasury is independent since 1920. So back to this, he says, yeah, they're not putting up anything. And I'm putting up my house. They're not actually giving me lawful consideration. And this, the reason I'm showing you guys this, and we'll go into it more on Thursday on the next show, is because this voids any financial contract, any contract that is using Federal Reserve notes. And this is so serious that what I'm showing you right here isn't even the case. This is the denial of an appeal. Okay. It's a denial of an appeal because they used Federal Reserve notes to pay for the appeal. And he said, no, look, this court determined that the said notes on their face were contrary to Article 1, Section 10 of the Constitution, which says that no state shall issue any note of indebtedness of the United States, and also based upon the evidence deduced at the hearing on December 7th, 1968, the notes were without any lawful consideration, meaning it couldn't be redeemed in gold, and were void. However, this court indicated that it would give the plaintiff, First National Bank of Montgomery, a full and complete hearing with reference to this issue. No hearing was requested. So this is the denial of their appeal on the decision, right? So it says, an action for the recovery of possession of real property was brought before this court for trial on December 7th, 1968, 10 a.m. by jury. And it was it was in equity, a suit in equity, but it was under common law, right? A true and correct copy of the judgment and decree entered by this court in December 9th, 1968 is attached here too, as pages 14 through 17. 1969, this court filed a notice of refusal to allow appeal with the clerk of the district court, Hugo L. Henges, or whatever, for the county of Scott in the state of Minnesota, which is attached here too as pages 18, 19, and 20. And it says the Minnesota statutes annotated 532.38 required that the appellant, First National Bank of Montgomery, deposit with the clerk of the district court within 10 days $2 of lawful money of the United States, which would be 1 ounce silver coins, for payment to the justice of all people justice of the peace, a justice of the peace who, like I told you, at common law, he's just a magistrate. That's what it is justice of the peace is a magistrate separate from the tribunal because the jury decided this case. That's how common law works. Okay. Before whom the case was tried. This was one of the conditions for the allowance of the appeal. 2 $1 Federal Reserve notes were deposited with the clerk of the district court. One was issued by the Federal Reserve Bank of San Francisco with the serial number, blah, blah, blah. And the other on deposit was issued by the Federal Reserve Bank of Minneapolis, bearing the serial number, blah, blah, blah. A specimen for illustrative purposes is as follows right here. And then said that the notes are contrary and blah, blah, and denied their freaking appeal on the judgment because they used Federal Reserve notes instead of lawful money. How do you like that shit? They didn't use lawful money. Boom, struck the bank down. That's why the judge ended up not living too much longer after this case. And some of the jury members also ended up unaliving or being unalived. So let's see. Let's go down to 17, see if we actually, because I have the case. Let's see. I have the case on the other. He said 17, right? Judgment and decree. The above entitled action came before the court and a jury of 12 on December 7th, 1968. 10 a.m. Plaintiff appeared by its president, Lawrence V. Morgan, talking about the bank, the First National Bank of Montgomery. That was the defendant, the plaintiff. was represented by its counsel. Plaintiff appeared by its president, Lawrence V. Morgan, and was represented by its counsel, Theodore R. Melby. A jury of talesmen were called and paneled and sworn to try the issues in this case. It says plaintiff brought this as a common law action for recovery of the possession lot 19, Fairview Beach, Scott County, Minnesota. Plaintiff claimed title to real property in question. So this is what, just so you guys don't get confused, is so there is equity under common law, like I was saying, that's constitutional. The equity that they're doing now is under Roman civil law, and that's not constitutional. So this is equity at common law, or it's a suit in equity, but it's a common law suit still, but it's not a criminal suit. So that's the difference. And I know that gets a little bit confusing, but now Roman civil law is, like we read in Black's Law Dictionary, is distinguished from common law, right? And you can have equity in civil law, but it's a different procedure. It's entirely different procedure. Defendant appeared and answered that the plaintiff created the money and credit upon its own books and by bookkeeping entry as the consideration for the note and mortgage, right? He says, and alleged failure of consideration of the mortgage deed, and alleged that the sheriff's sale passed no title to plaintiff. So what he's saying is that he put up his house and they didn't have anything to put up in as consideration, because a Federal Reserve note is not payment. It's not anything. It's worthless, right? So Mr. Morgan admitted that, that's the Montgomery Bank guy, admitted that all the money or credit which was used as consideration. Remember, the word consideration is what is given in a contract, what is exchanged in a contract. So in order for a contract to be valid, I have to give you consideration. You have to give me consideration. It has to be equal and acceptable consideration, or at least be taken as equal consideration. Otherwise, the contract's not valid. That's why he won this. Okay. And so anyways, he admitted that it was created upon their books. He said all the money that we used for consideration was created on our books. And this was the standard banking practice being exercised by their bank in combination with the Federal Reserve Bank of Minneapolis, another private bank. Further, that he knew of no United States statute or law that gave the plaintiff the authority to do this. It's because he doesn't need that. This is common law. Right? This is the unwritten law of this is the common law of contracts, is you have to have equal and valid consideration. Plaintiff further claimed that the defendant, by using the ledger book, created credit, and by paying the issues in this case were simple. There was no material dispute on the facts for the jury to resolve. Plaintiff admitted that it, in combination with the Federal Reserve Bank of Minneapolis, which for all practical purposes, because of their interlocking activity, blah, blah, blah. So basically he won and he got to keep his house and he didn't have to pay shit. This is the actual case here as well. Like I said, sometime this week, I'm going to create I'm either going to use my Google Drive or something, and I'm just going to give the password out, and we're going to start making this available, this type of stuff available. So, Patrick Henry's advice, yeah, blah, blah, blah. So this is the actual case, but now I'm going to show you some other ones where they also, so this is Eckert v. the Commissioner of Internal Revenue from 1930. And this says right here, the giving of a note does not constitute a cash payment. The obligation to pay the amount of the note may be as binding, for instance, as payment of taxes, which is what's secure in the note in the first place, right? But it has been determined that a taxpayer on a cash received and dispersed basis cannot deduct taxes before they are actually paid. Now, look, this here, it actually gives you another clue too, because what they use as security to issue all the other securities is the public charitable trust, right? That's put up for the 14th Amendment infant pauper. Now, it doesn't say that in here, but this is what he's talking about. The United States v. Mitchell Super, nor can the taxpayer who subscribes to a charitable fund deduct the subscription until he has paid it, right? So think Social Security. Now that trust sits there and it has an equitable value, right? That they borrow against even before you ever put anything into it. They're already borrowing against it and using it as surety to issue other securities, which are notes of indebtedness or evidences of indebtedness. When I say security, that's what that means. But you cannot access the Social Security until you've paid into it. Not only that, but you have to reach a certain age because it's a deferred retirement benefit. And see, that's another thing that makes you an infant. The fact that you are paying into this charitable fund, right? The fact that you do need that plan for retirement because you're incompetent and capable of handling the affairs of your own estate, right? So, yeah, civil law is Roman civil law. That's Black's law. I'll show it one more time over here. Civil law, the Roman law, and the civil law are convertible phrases, meaning the same system of jurisprudence. It is frequently denominated the Roman civil law. Down here, it says, as distinguished from the common law of England and the canon law, which is obviously the church law and judicial canon. So, which is church law still. But, and then over here, just so you guys are clear, or I'm sorry, right here, it says that, where are we at here? Okay. The author was induced to believe that that an occasional comparison, so this is Bouvier's Law Dictionary from 1854, and it's adapted to the laws and Constitution of the United States, and he refers to civil law all through this as a foreign law, a law foreign to the United States, does not belong here. We do not practice that here, okay, until the freaking attorney, the bar pirate, came over and took over the system of law, just like Thomas Jefferson said. Through the constitutional judiciary, through the Constitution, the judiciary will work like gravity by night and by day to usurp the sovereignty of the states. That's what happened by basically pulling everybody into civil law through presumption and contract and effectively barring you from common law, or so they think, they claim, but all you have to do is know how to practice it and know how they've committed fraud, and there's nothing they can do. You can practice common law all you want, and you can really fuck them over. That's what we teach in our Juris Society class, which if you're interested in becoming a member, part of that is you get the access to once I get my drive onto my SD card onto the Google Drive, you'll get the password to the Google Drive. Plus, we actually go through and we learn how to first claim your estate, and then also how to draft actions and defenses, or how to write actions and defenses at law and in equity, but primarily at law, because you don't even really want to ever end up in equity, especially not since it's been infected by, all right, now that it's Roman civil law equity. Basically, you don't want to be under it at all, because the house always wins. You have none of your sovereign rights or authority, and the judge is the tribunal in civil law. That's the big problem. That's why the attorney wanted everybody to be in civil law. It's because the judge is the tribunal. The attorney is God. The attorney is the tribunal. And that's why they did that. But anyway, so let's look where he refers to this as foreign law. So throughout this whole thing, he says he's talking about why he includes some foreign terms in this dictionary. So here he explains why he includes foreign terms. He says the author was induced to believe that an occasional comparison of the civil canon and other systems of foreign law, right here it says foreign law, with our own, meaning civil law, canon law, and other systems are foreign to American law. We do not have civil law here. There is not supposed to be civil law here at all, ever, under no circumstances, right? There was only one state in the Union that had a form of civil law. They used it for their civil code, and that was Louisiana, because it was under the French, which is basically Roman civil law that was in France during the time of Napoleon. And so when Jefferson bought it from Napoleon, Louisiana was still under and just kept that civil code. So, yes, they are the OG mobsters, Jeff. They are. They're fucking, yeah, they're the coldest that have ever done it, ever in the history of ever. They're the most gangster pirates that have ever existed. They're inland pirates. They're still committing piracy. We were talking about letters of marque and reprisal in the last stream. Well, the bar license is basically a letter of marque and reprisal. It allows them to these privateers, these esquires, to plunder the vessels of enemy sovereigns. So they send their little pirate gangs out called policy officers to go and capture and seize and capture vessels. And then they pillage and plunder them, generate securities off of them in their banks that they pretend are courts, all through special administration and probate, all through Roman civil law. So, but initially always has to start in common law in this country because they still have to follow the law. So they pull you, they use presumption of infancy and incompetence and death to pull you out of common law and into Roman civil law under administration of your estate, and then generate constructive trusts from the first charitable trust that you have, your social security number, which is what I like to call an underwriting investment trust, that they use as when I say security or surety, right, to generate securities, it's in order to generate an evidence of debt, there always has to be something to secure it to be used as surety. And so you are the very first basis of surety for everything, your sweat equity. And then they start generating all this commercial paper off of your sweat equity. And that's how they do it. And then they use that commercial paper as currency, even though it's not. So let's flip back to that so I can go to bed here shortly. All right, so we did Eckert. Let's do, this is, what the hell is this? Case file, this is a long one. It's called, I got notes, Black Shear Manufacturing Company versus Harl. And this is from 1940. So even as late as 1940, we're going to see that bank checks and promissory notes are not payment until they themselves are paid, or until themselves paid. And a promissory note, which is what a Federal Reserve note, taken in renewal of a previous note or for the balance due on such note or account, will not until that note is actually paid operate as payment. And that's all we do in this country. What he just said, a promissory note taken in renewal of a previous note or for the balance due on such note, that's all we're doing is just trading debt. Oh, I owe you, you owe me. And see, because there is no money, there cannot actually be debt in this country. And that's an entire other concept that's like mental acrobatics to wrap your mind around. But once you see it, you'll be like, oh my God, eureka. That's amazing. Yeah, there cannot be debt in this country. So actually all we're doing is trading, right? And because that's like why you get an inventory receipt instead of a bill of sale from the grocery store or anywhere else, you get an inventory receipt. Right? Because all we're doing is exchanging debt back and forth. And because that's why you're supposed to be able to discharge your debts through the Treasury, but do not do that and do not try to do that, because if you do that, then you're accepting a benefit and you're for sure an infant, right? But that was one of the pressure valve reliefs they had to set up with the gold clause. And then they, of course, removed the gold clause because the House always wins in their commercial game of, in their commercial law. So, anyways, so it says that, and a promissory note taken in renewal of a previous note or for a balance due on such note or an account will not, until that note is actually paid, operate as payment or operate as an accord and satisfaction or novation extinguishing the previous note or indebtedness. And, I say this all the time. If the United States, yes, they did. They changed gold and silver for living souls. Yeah. Well, actually, they got the gold and the silver and the living souls. We actually just let them take it all through usury was what happened. They traded us worthless paper for our gold, silver, and souls. Yeah. So what a good deal that was. But no, like he said, so all we're doing, or like I tell people all the time, if you literally, if the United States were to pay off all of its debt somehow, magically come across a big cache of gold, like literally a whole fucking nation full of gold, and we're able to pay off its debt, it would destroy the economy because all of our currency is debt. So we'd actually have to just immediately switch over to something tangible, which ultimately is what Trump would have to do, is switch over to something tangible and probably tell the Federal Reserve to go fuck themselves and the IMF and everyone else, the International Bank of Settlements, would go fuck yourself. You can never pay that. What are you talking about? In fact, what you did was fraud in the first place. So go fuck yourself. But so anyways, yeah, this is an entirely, this whole case is excellent. Under the defense of the maker that a last note given in transactions between the debtor and creditor had been fraudulently obtained, and in the absence of any evidence of agreement between the parties that such note should operate as payment, accord and satisfaction or settlement of a previous note and alleged indebtedness, the mere taking of the last note would not extinguish the previous obligation or any of that. So essentially what that means is the only way that a Federal Reserve note can be, or a promissory note in general can be taken as payment, is if both parties mutually agree that it is payment, that it will be payment. All right, one more, guys, one more. This is State v. Nealon, right? And this is from, what year is this from? Hold on. And I'll link all these in the chat for you too. 1903. Checks, drafts, money orders, and banknotes are not lawful money of the United States, and they could not find the defendant guilty unless they believe that he converted or failed to account for the United States coins or treasury notes, commonly called greenbacks. So right here. So the Supreme Court has held time and time and time again that promissory notes do not constitute payment. So what is a bank giving you when you take out a mortgage? Nothing. You generate the credit, first of all, with your signature. Okay, you create the promissory note that they exchange. Basically, think about it like this. You create the promissory note, they take it to the Federal Reserve and say like your promissory notes for like $150,000. All they're doing is basically breaking a bill. You could look at it like that. They're taking a $150,000 note and giving it back to you in hundreds. Instead of just one $150,000 note, they're giving it back to you in hundreds. But it's your note. You created it. The bank did nothing. The bank did nothing at all. That promissory note is your note. You created it with your credit, with your signature, and the bank literally did nothing. Does that make sense? It's the same. Your promissory note's the same as the Federal Reserve. In fact, yours is more valuable. Yes, negotiable instrument. It's a commercial paper is a good cover-all term for it. It's commercial paper, but a mortgage is specifically a promissory note. So, and that's the whole thing. And you've got when you sign a mortgage for $150,000, right? You just created a $150,000 note. And then all they do is take and give that to the Federal Reserve in exchange for that same amount in Federal Reserve promissory notes and give it back to you and then charge you fucking interest on it and fees. And it was yours the whole time. You did nothing. The Federal Reserve did nothing because they both those banks are just giving you what you just made, giving you back what you just gave them in a different form. And it's the same fucking thing, except now you owe them interest and fines and fees, or not fines, but fees. And then now they can take your house too if you don't pay them back your own, like what you just created. So that's the crazy thing about it is you made the promissory note, then they cash it into smaller promissory notes, use that to buy the house. It was yours the whole time. You could have technically just took the promissory note and bought the house if things worked properly, right? But then if you don't pay them back, what you're not paying, see, even using the term pay them back is wrong. If you don't double pay them, right, then they get to take your house. So, and not to mention that, but while the mortgage is outstanding, they can also generate more commercial paper from that mortgage and use that mortgage as surety, right? And make even more money. They can bundle the mortgages together and sell them to private investors, all sorts of stuff, right? Make even more money. That's the crazy thing about it, dude. So you are the only thing of value in this country. So with property tax, here's the thing though. Property tax, you only pay property tax because the property has been registered and your estate is under administration and you're presumed to be the infant trustee of the estate, not the actual heir or owner of the estate, grantor of the estate. or of the not the grant. Well, yeah, I guess you could kind of say it, but you're not the owner, so they're charging you a fee for the use of something that they presume not to be yours, and that's what property tax is, because they hold the superior title through registration. Where in reality, once you claim your estate and you go get an abstract done, like I was telling one of our Juris Society members, you go get an abstract done, find the last time that a person actually held the actual title granted by land patent before it became a warranty deed from the Torrens registry system, and then see if it was entered into the Torrens registry system properly by adjudication, meaning in a courtroom. And if it was not, then you can take that property out of the registry system and claim the allodial title on it and never pay another fucking tax in your life. And 9 times out of 10, when you do that, or when you go down and try to get the actual title from the county, they'll try to settle with you and be like, well, what about a homestead exemption? That's what a lot of people end up coming across, is a homestead exemption. Yes, double pay and double debts. That's right. So he says, one of my understanding is that the Bill of Rights was an appeasement to the people to placate them into time. So no, that's not what it was. It was actually the work of some patriots, Patrick Henry, Thomas Paine, and Thomas Jefferson. Would see when they ratified the Constitution, they did it while Thomas Jefferson was over in France dealing with the pirate situation, Tripoli. And when he came back, he found out what they had done to the Articles of Confederation, and him and Patrick Henry and Thomas Paine rallied the people to have the Bill of Rights amended to the Constitution in order to not have just fought the Revolutionary War for no reason. That's what Thomas Jefferson said. If you don't get a Bill of Rights amended to this Constitution, you just fought that war for no reason. He said the judiciary, or through the Constitution, the judiciary will work like gravity by night and by day to usurp the sovereignty of the states. And he knew that they were going to do it through probate. He didn't say that, but now I know that's what he knew, because I see exactly how they've done it. And so, no, and that's the whole thing. The Constitution was a con, but the Articles of Confederation were impenetrable. And that's why they had to have the Constitution. Right. And another thing is the Articles of Confederation didn't go anywhere. You'll find Supreme Court cases all the way through the early 1800s reference the Articles of Confederation as a founding document, because the Constitution didn't create the states. The Articles of Confederation did. The Constitution created the centralized federal government and gave it all the borrowing power and all power over commerce and bankruptcies and the ability to create inferior courts and all that shit. Right. And the underhanded shit that they used against us, that they still use against us. But the Articles of Confederation created the states. That's why I tell everybody that all states are Confederate, all of them. And I've shown it many times. It's in this revised statutes of Michigan right here. It's in the appendix way at the bottom. It says that she's solicitous to give to her sister states proof of her desire to promote the peace and tranquility of the Confederacy. So, yeah, I'm not going to look for it right now because I got to get off here, but I have shown it a couple times. But the Articles of Confederation, basically because they could keep, what was I going to say? Or actually, this is the 1827. It's in the 1836 one. It's not in this one anyway. But anyways, the reason that they did that is because the Articles of Confederation, you could actually recall a delegate. So delegates went to Congress, the United States and Congress assembled on 1-year terms, and they could be recalled at any time throughout that year for any reason and replaced with another delegate. So you have no lifetime senators. You had no centralized borrowing power. You had no centralized control over commercial activity, which is how they do everything right now, is by centralized borrowing power and centralized control over commercial activity, because everything is taking place in commerce. That's why everything needs a license from the president, which is ultimately even what your driver's license is, through the Secretary of State, who's an agent of the president. It's part of the executive branch. And that's from the Trading with the Enemy Act as amended by 1933, or in 1933. So yeah, that's what we got going on there. But yeah, there is no money. Bar attorneys are not supposed to be here. They're unlawfully here as pirates, per the 13th Amendment, the real 13th Amendment of the federal Constitution, the Titles Nobility Amendment that they want you to believe was never actually ratified, even though it was on the law books for 20 years, over 20 years. So that's bullshit. All these learned people back then, nobody realized that there's, oh, well, this wasn't actually ratified. Whatever, dude. Get the fuck out of here. Liars. Well, but anyways, guys, I apologize if I was if I misspoke or had trouble reading or anything. I said I literally been up about 24 hours now, so I gotta go get some sleep. I appreciate you guys joining me as usual. If you're just now popping in, I'm sorry you missed the live stream. Go back and watch it from the beginning, though. I think it went pretty well, even being tired. Let me know what if you guys want me to get more into the promissory notes on the next public class. And of course, we're going to have our Jurist Society again Friday at 10:15 for the members. And we're going to pick up where we left off in the declaration of claim to claim the title to your estate on the record. We're going to go through and we're going to explain what each paragraph means, why it's written the way it's written, and how it's going to work, how to stand on it. And yeah, I'm pretty excited to actually get into the meat of that. And if you're interested in becoming a Jurist Society member, if you're on Rumble right now, I'm only doing the membership on YouTube just because it's easier. But it's Burn the Corporate Fiction at YouTube, on YouTube. And if you're on YouTube, there's a link in the description of this video. So, hey, thank you, Barb. I appreciate it. Oh, I'm going to get back to your email. Like I said, I was out of town yesterday and stuff, so I'll get back to your email. I forgot to actually get back to a couple of you this evening. So. And I would appreciate your help as well with the designing and stuff. So, all right, guys. Yes, Eastern Standard Time, 10:15 Eastern Standard Time on Friday will be the Jurist Society members only class. And then, as always, we'll have another show during the week, a public show, and it'll be good stuff like this. If you guys want me to get more into I do need to get more into the probate code as well, though. So. Yeah, maybe we'll do probate code on Thursday. I don't know. Well, we'll play it by ear. So, all right, you guys have an awesome day. Thank you for joining me, and I will see you Thursday morning.